Welcome, everyone. As Michael said, my name is Mark Storsley. I'm the Executive Director of the Constitutional Law Center. And over the course of the next day and a half, I suppose, you'll see me and then my colleagues, sort of who you'll meet in turn, serving as moderators for these various panels. Before we get going on our first panel, Fixing Equality, I just want to say a few words about sort of the nuts and bolts about what's going to be happening. So first, just in terms of mechanics, each of you should have received when you came in a booklet that lists where you can find more information about each of our presenters, and also this handout, which has all the proposed constitutional amendments that we're going to be discussing contained in it. We'll also have those amendments projected on the screen so you can follow along here. In terms of format, what we're going to do is maybe a little bit different from some other usual conference formats. We've asked each presenter to talk about their amendment, their proposed amendment, briefly for about 10 minutes. And then following each presenter's presentation, we've asked a commentator to offer some comments on those proposed amendments at the podium that you see to my left here. So the commentators are sort of sprinkled through the audience, and they'll come up and join us immediately after the presenter on whose amendment they're commenting on. I will be keeping time as we're doing this, and that's unfortunate, but it's necessary to sort of make sure that everybody gets their word in and we have some time left for questions. So to do so, I've devised some just very ugly signs. So if you see some, sort of very loud green shouting at you from my direction, that's what's happening there. But we do ask that for the presenters and the commenters, please be conscious of the time in your comments. I think that's all that I have in terms of basic ground rules. We'll see how this works. So allow me to just offer very brief introductions for each of our panelists so that we can spend most of the time talking about the amendments themselves. So the first panel is Fixing Equality, and we've invited several great panelists with what I think some really fascinating proposals to talk to us. Mary Ann Case, to my far left, is a professor of law at the University of Chicago. Jane Schacter, to her right, is professor of law at Stanford Law School. George Thomas is a professor of American Political Institutions at Claremont McKenna College. And Amy Wax is professor of law at the University of Pennsylvania Law School. So as I mentioned, we'll be hearing sort of from commentator-presenter in that form. So without further ado, Mary Ann.
Thanks very much. Unlike most of the amendments I think you've got in front of you, mine is going to be familiar to most of you. It is the Equal Rights Amendment, in haec verbis, proposed in the 1970s and not yet ratified. Let me tell you why I went with some might think is a cowardly route and some might think is not a big fix, but maybe exactly what McConnell did not want, which is a tweak. Let me start by saying, my general answer to should we amend the Constitution or rewrite the Constitution is please no, because I think opening it up opens up a large can of worms. And that's true about the Constitution more generally and about the area I'm talking about more particularly. If I were to think about what called for a big fix, most of the things I think call for a big fix are all structural, but I think that as a citizen and formulating and arguing for such fixes is not something I'm particularly well qualified to do as either a lawyer or an academic. So I'm sticking to what I know best and care about most, what I, as a single issue voter, would give my vote to, and that's the equality of the sexes. I have described myself elsewhere as a feminist fundamentalist, that is to say, someone whose commitment to the equality of the sexes is as deep-seated and as uncompromisable as a commitment, as the commitments of religious people to some of their religious commitments. I had said before that I think the commitment of the United States to the equality of the sexes is similar, but now I am worried. So I'm on the panel Fixing Equality, and I'm going to take the word fixing as a pun. Fixing as in making certain. The last time I was at a similar event, some of you were also panelists at that, Is It Time to Rewrite the Constitution, was in that innocent time shortly before the election of Donald Trump, in which I approached the question whether it's time to rewrite the Constitution and said even more certainly no. Because when it comes to this single issue of sex equality, I am content with the actual language of the US Constitution and also content with the way it has been interpreted by what I think of as the Ruth Bader Ginsburg revolution in the case law of the last half century. But I am concerned I was concerned even then, several years ago, when voices as seemingly disparate as Justice Scalia on the one hand and Roberta Kaplan on the other, the attorney for DOMA plaintiff Edith Windsor, disparaged the need for heightened scrutiny for sex discrimination and seemed to embrace the reintroduction of sex stereotypes as a basis for state action. My concern is even stronger now that originalism is back with a vengeance on the Supreme Court and in the lower federal courts if the more appointments Trump seems to be able to make. I wrote about the problems posed for feminists by the originalist turn in a piece called The Ladies Forget About Them. This is a riff on Abigail Adams saying to John Adams, remember the ladies. And the more I looked at the original intent of both the framers of the original Constitution and the framers of the post-Civil War amendments, and I set this out at much greater length in that piece, I'm convinced that the ladies were not forgotten, they were remembered, and it was specifically decided to exclude them in a sort of structural way. That is to say, when John Adams said, do not remember the ladies, or even said to, I cannot but laugh to Abigail's proposal that the men be more just to them, it was a decision about the allocation of power akin to the decisions made concerning federalism or the separation of powers. It's the notion that women had so much power in the home that to give them more power in the state and to give them equal rights would be to give them way too much power. Similarly, at the time of the 14th Amendment, the framers very specifically considered whether equality for the newly freed slaves would translate into equality for their wives and daughters, and they very specifically said no. Now, I realize that a lot of originalists are trying to reformulate that history so as to say, yes, indeed, originalism is compatible with what I'll again call the Ruth Bader Ginsburg revolution. That is to say, our current well-developed constitutional case law of sex discrimination, which essentially stands for the proposition that no fixed notions concerning the roles and abilities of males and females is constitutional when embodied in law. And the fact that originalists are doing this cheers me as a feminist, but I can't support it as a scholar. It's just not sustainable. I find myself frequently agreeing descriptively with Justice Scalia, and his dreams are my nightmares, but when we connect the dots, we see the same figures. And he actually said exactly what I think is correct. He was asked by Calvin Massey about whether applying the 14th Amendment, whether equal protection applies to sex discrimination, and he says, no, it doesn't. If the current society has come to different views, that's fine. You do not need the Constitution to reflect the wishes of the current society. The Constitution does not require discrimination on the basis of sex. The only issue is whether it prohibits it. It doesn't. Nobody ever thought that's what it meant. Nobody ever voted for that. The current society wants to outlaw discrimination by sex. We have things called legislatures. They enact things called laws. You don't need a Constitution to keep things up to date. Now, he backpedaled completely shamelessly from this when questioned later. He said, he was talking about Title VII. I mean, I just read you the quote. He clearly wasn't. Or no, he didn't mean it. As I say, I fear whether or not he meant it, principled originalism can only come to the conclusion that the case law from Reed v. Reed through Hibbs is in danger, right? If stare decisis isn't what holds it in place, then it's in trouble. So one of the other reasons I introduced the text of the Equal Rights Amendment as it exists is that the original meaning of the Equal Rights Amendment, whether you talk about the opponents from the 70s to the present, Phyllis Schlafly or Chief Justice Rehnquist, they both said, what this will do is upset the division of labor between men and women. It will upset the family. It will lead to same-sex marriage, unisex bathrooms, women in combat. Well, we're well on our way to that, and I'm very happy about it, right? I would like to fix not only the text, which I wouldn't have picked because I prefer general constitutional guarantees to ones singling out particular forbidden grounds, but the meaning, both as embodied in the case law and as finally accepted at the end of his life by Chief Justice Rehnquist, who, you all know is a big fan of federalism, but nevertheless said, we have such a strong commitment to the equality of the sexes, and not only to the equality of the sexes, but to the sectarian instantiation of it in no fixed notions concerning the roles and abilities of men and women, no stereotypes about who should be doing domestic labor and who should be doing market labor, that the Congress had Section 5 power to enforce it against the states. That's the holding of Hibbs. So again, I'm terrified that if we bring one of the things that wasn't clear about this conference is whether we just get to propose or whether we get to dispose of our amendments. If I'm just proposing the reason why I said at the Wisconsin conference, I said it was either too soon or too late to propose the ERA, because I would have been happy had it been passed then, and Ruth Bader Ginsburg is not alone in saying our current constitutional law of sex discrimination is exactly what the ERA would have called for. So I am in favor of fixing it.
Thanks, Amy. Or Mary Ann, excuse me. Now we're hearing from Mike.
I think Amy will be very offended.
Right.
Stand for very few of the same things.
Well, hello, my name is Mike Paulson. I'm honored to be here to comment on Mary Ann Case's proposal. Mary Ann is one of the most persistently provocative and interesting constitutional scholars in America today. We agree on almost nothing. She's a feminist fundamentalist. I'm a conservative, Christian, original public meaning textualist feminist, because we actually agree on this one. So I've entitled my brief comments "A Friendly Amendment," because I think this is a friendly amendment. I'm friendly to it. And I will also use it in the other sense, in that I think I have a couple of tweaks to the amendment, to suggestions to how to improve it. So I'm going to make 5 points in 5 minutes. Can I do that? Okay.
We'll see.
First of all, I'm in general support of the text of the proposed Equal Rights Amendment, which I regard as being just an application, a straightforward application of the principles of the Equal Protection Clause. And here I should explain what a pure original meaning textualist thinks. It is not the subjective intentions of the drafters of language that matters. What matters is the original public meaning that the words would have had to speakers and readers of English language at the time. I think if you apply the original meaning approach to constitutional interpretation rather than intentionalism, you would conclude that the 14th Amendment forbids states from denying equal protection of the laws to any person. Women are certainly persons. They were understood so at the time, and I think the most logical, correct originalist meaning is that the 14th Amendment's Equal Protection Clause prohibits government discrimination on the basis of sex as to rights, privileges, and benefits, unless there is some intrinsic difference between the sexes that justifies it. Now, that approximates very closely, as Mary Ann said, the current doctrine of the U.S. Supreme Court, which I think is essentially correct as it has evolved, at least as with respect to sex discrimination. I think the Supreme Court has ultimately vindicated the original meaning of the 14th Amendment's language. Now, then the question is, what's the point of this? Okay? I think there is a value of symbols, and that I would support the adoption of the Equal Rights Amendment as a confirmation of the meaning of the Equal Protection Clause. There is no sin in redundancy, and I think that there's of value to fixing in place the meaning, okay? Whether it's a big fix in the sense that Michael intended it, I have my doubts. It's not much of a change, and it doesn't really correct anything in a major way. And I'm going to raise just a couple of quick interpretive points about the amendment. Possible reservations about the idea of adopting it. One is, courts go kaflooey when there's new language because they want to presume that the new language changes something material, and they will often strain the meaning in order to give the new language some effect that it might not have been meant to have had. I think there's a danger in this situation, and there are also some new ambiguities in terms of equality of rights under the law, okay? As current doctrine has it, and under the equal protection of the laws, there would not be a limitation to specific rights, but it would include benefits and privileges as well. I think there's a danger that this language could be read inadvertently as narrowing the scope of the equality principle with respect to women. Secondly, there's always a question when you adopt new language, are you incorporating and locking into place, fixing in place, past judicial interpretations of similar language? I would be especially concerned about that with respect to the enforcement clause. The Supreme Court has been all over the place in terms of the meaning of the power of Congress to enforce by appropriate legislation these civil rights things. And one of the cases that I most despise is City of Bernie versus Flores, which I believe narrowed the enforcement power. I believe that that Nevada versus Hibbs reflects a correct understanding, but I think it would be important to clarify things like that. And so here's my friendly amendment to the amendment of the Equal Rights Amendment. And that is actually to go back to the original proposal from 1923 from, I think this is a Representative Alice Paul.
She wasn't a representative, but Alice Paul, yes.
It's the Alice Paul language that said, men and women shall have equal rights throughout the United States and every place subject to its jurisdiction. And then that Congress shall have power to enforce by appropriate legislation. I think by adopting fresh language that is less ambiguous than the Equal Rights Amendment is, you would actually clarify and better accomplish what you were intending to do. And I support that. I had a last point, but I have only 30 seconds left. Let me tell you what my point would have been. There is a movement afoot to resurrect the old Equal Rights Amendment and saying, oh, even though the time has expired for ratification and Congress probably unlawfully extended it for another 7 years, that we can still ratify it. This is interesting because I was searching the internet for what's going on with Equal Rights Amendment. Nevada, just a couple of months ago, purported to ratify the expired proposal of the Equal Rights Amendment. My short point is you have to start fresh, and as long as you're starting fresh, start fresh with a little better, more precise language that actually accomplishes what you want to have done.
Thanks, Mike. Next, we hear from Jane Schacter. I promise I'll get your name right.
So my amendment, as you can see, is about the right to vote, and you might wonder if I've been placed on the wrong panel because we have an election law panel later, but please don't blame the organizers. I wanted to make this proposal in the context of equality issues, because as I thought about the ways that the Constitution might be amended to better pursue equality, I was hard-pressed to think of anything more important to redressing significant inequalities today than to better protect the right to vote. Taking seriously the conference's imperative to think big and disregarding any question of political viability, I propose robust constitutional protection for voting. So my amendment would create a fundamental right to vote, one that extends to those with criminal convictions, and impose a new duty on states to facilitate voting, affirmatively facilitate voting. The amendment is motivated by the idea, famously recognized in Yigwo versus Hopkins, that the right to vote is preservative of all other rights, and it's also animated by both prongs of John Hart Ely's theory. Recall that Ely proposed a more aggressive role for the courts, where first, the ins are choking off the channels of political change so as to entrench their own power. And second, some minorities are denied meaningful representation in the political process because of hostility and what he called the distorting lens of prejudice. By more strongly protecting voting, this amendment aims to make the democratic process function better and more equitably, and to increase the representation of those that vote the least, the young, the less affluent, the less educated, and to create a constitutional barrier to some of the practices that continue long-standing historical patterns of burdening and undermining African Americans in particular. My aim, then, is to bring more equality to the democratic process, but it's also to recognize that in the long run, the democratic process can address a wider range of inequalities than can the courts through application of the Constitution. So in a different way than constitutional amendments target at particular inequalities, extending and protecting the franchise can promote equality over the long term by broadening and equalizing the range of voting power, the range and voting power of interest to whom elected officials must respond. So the amendment has three pillars. First, it defines the right to vote as fundamental and mandates strict scrutiny for any measures that deny, abridge, or impair it. Now, the Supreme Court has already branded the right fundamental under the 14th Amendment in cases like Harper versus Virginia and Reynolds versus Sims. Now, one problem is there's always been a textual awkwardness of grounding the right in the 14th Amendment's Equal Protection Clause, given that the 15th Amendment, just a few years later, expressly addressed voting, and the Equal Protection Clause of the 14th Amendment did not, and also that the 14th Amendment addressed voting in Section 2 of the 14th Amendment in its reduction of representation clause. So one thing would be to beef up the textual grounding, but I think the more important impetus to do this, to make the right to vote a fundamental one subject to strict scrutiny, is that the Supreme Court's declarations of fundamentality in cases like Harper and Reynolds have been swamped by the court's willingness to apply an often deferential balancing test to many measures that meaningfully impair the right to vote. So under the Burdick-Anderson line of cases, courts will not, absent a severe burden, impose strict scrutiny on many practices. This is the test that the court used in its Crawford versus Marion County decision on a facial challenge to voter ID laws. So my amendment expressly mandates strict scrutiny for anything deemed not only to deny, but to abridge or impair the right. The basic idea is that courts should view as presumptively unconstitutional and suspicious measures that impair voting. I should note as well that Section 2 of my amendment tracks language in Section 14 of the Voting Rights Act to define voting broadly, so the protection extends beyond the single act of casting a ballot to registration and to having one's vote counted. Second, the amendment extends the right to vote to non-incarcerated people who have been convicted of a crime. The theory is that people in this category are, once out of prison, members of the community, including the political community, with a stake in its collective choices. So this part of the amendment is intended to overrule Richardson versus Ramirez. It stops short of a full ban on any criminal disenfranchisement, but would reach all but the approximately 21% of those currently disenfranchised who are in prison. Third and finally, it imposes an affirmative duty on states to facilitate the right to vote. This feature, along with the relatively specific language of what that duty entails in Section 2, is most strikingly different from most of the provisions in our existing Constitution, and that is by design. In the favored jargon of Silicon Valley, it is meant to disrupt. It tells states that their job is to enable eligible voters to vote, including by offering meaningful alternatives to election day voting, such as early or mail-in voting, though it does not mandate any single practice for such alternative voting. It does, though, mandate universal registration, the practice used in some states, where residents are automatically registered when they interact with a state agency, say to get a license or permit or public benefit, unless they decline to register. So the intent here is to switch the default on voter registration so that voters must opt out of, not into, voter registration. So overall, the aspiration is to newly require states to promote and protect rather than to limit voting. And paired with strict scrutiny, it's a two-pronged effort to introduce new and significantly different constitutional and political norms with respect to voting. Now, it's not hard to spot some potential problems. One is, do I really mean to mandate strict scrutiny for every aspect of election administration? Will that cripple the state's ability to efficiently run elections? Well, my thought was that the verbs abridge or impair are going to do a lot of the work here. Regulation that neither denies, abridges, nor impairs voting will not trigger strict scrutiny. I considered using the strict scrutiny formulation from RFRA, But I wanted to avoid the word burden so as not to appear to codify the status quo in which we have nominally a fundamental right to vote, but plenty of state latitude to regulate in vote-suppressing ways under a balancing test that looks to the severity of burdens on voting. Still, it's probably inevitable that some form of two-track scrutiny will reemerge, and not all regulations will trigger strict scrutiny. But the hope is that the wording of Section 1, along with the affirmative duty in Section 2, will preserve strict scrutiny for policies that function to meaningfully limit the ability of individuals to vote or have their vote fairly counted. For an example, consider a Missouri Supreme Court decision that applied strict scrutiny in striking down a voter ID law under the state constitution, which recognized a fundamental right to vote. The court recognized there was a compelling state interest in preventing fraud, but found that the particular IDs required, a narrow set, flunked the narrow tailoring prong. So this is a case that might well have come out differently under a more forgiving balancing test. A second issue is line drawing with respect to criminal disenfranchisement. The numbers of disenfranchised voters has ballooned in recent years with a well-known disparate impact on African Americans. 1 out of every 13 African Americans is disenfranchised by a law of this kind. It's not only a racial issue, though. Some 6.1 million voters in all are disenfranchised, including 1 out of every 56 non-African American voters. So in reforming these policies, there's any number of places to draw the line, from no disenfranchisement at all, including for the incarcerated, and a few states do that, all the way to permanent disenfranchisement that persists after prison and completion of sentence, parole, and probation, as several states do, and various stations along the way. My amendment draws the line at disenfranchisement after release from prison based on the idea that such a line rightly prevents excessive continuing punishment for those deemed otherwise fit to return to society. It recognizes political citizenship as part of civic reintegration. And arguments can be made for restoring rights more or less expansively, but I opted for a bright line with a plain and intuitive justification that would restore voting rights to more than 3/4 of those who are currently disenfranchised. Finally, the addition of an affirmative duty to protect an individual right is an unfamiliar addition to a Constitution mostly oriented to negative liberties and restraints. Yet, affirmative commands are not entirely unprecedented. Some provisions in the Bill of Rights impose affirmative duties by text, for example, speedy trial under the Fifth Amendment, or by judicial interpretation, right to counsel for individual defendants or administration of Miranda warnings. In addition, as a matter of statute, states are under some affirmative duties in the realm of voting, as for voters with disabilities or limited English proficiency. And to take one comparative example, the Canadian Supreme Court has interpreted that country's charter to create, quote, a positive obligation on the state to put in place appropriate arrangements for the effective exercise of the right to vote. So my proposed amendment provides some specific guidance about universal registration and expanding the times for voting, but it seems inevitable that the precise parameters of the affirmative duty will have to be worked out through experience and interpretation. Together with strict scrutiny, the amendment attempts to signal the repudiation of practices that discourage or undermine voting. Now, one final note. Given the strong partisan motivations afoot in setting voting policy, there is reason to suspect these new constitutional commands might well meet resistance from states as well as some judges. I have no illusions that there will not be pushback, creative attempts to circumvent, and strategic behavior of the kind we see commonly in the realm of elections. But this amendment attempts to reconstitute, if you will, the idea of voting by administering a constitutional jolt and giving new tools to advocates for greater equality in voting and through voting. Thanks.
Thanks, Jane. We'll now hear commentary from Michael Ramsey from the University of San Diego.
Thank you very much for inviting me to comment on this very interesting proposal, and I think I'm in a unique position to do that because I know absolutely nothing about election law, or indeed really about equality law. I'm a separation of powers guy, as you'll hear about tomorrow. So therefore, though, I don't have any stake in the current policy and empirical debates about election law and what to do about it. So I can sort of take a sort of long and uninformed view of how this proposal might play out, and I think that's appropriate in considering a constitutional amendment, which should be something that should endure for the ages, or at least, as Jefferson said, for a generation or so. Let me offer two observations. I've cut it down from 5 to 2 about the proposal. The first is that in general, it seems to me that when we're thinking about voting, that we're concerned about two big things. And one is that everyone who's entitled to vote should have the opportunity to do so. And the other is that no one who's not entitled to vote should be able to do so. And my first concern about the proposal is that it seems to focus principally on the former at the expense of the latter. It likely makes anti-fraud provisions substantially more difficult, or at least invites courts to take a closer look at, and therefore I think discourages such provisions. But I think that anti-fraud provisions are a legitimate concern, and it's important to acknowledge them in election law, and that's irrespective of any empirical claims about anything that may or may not be going on today, or may or may not have gone on in earlier times in places like Chicago. But the integrity of the voting system, the integrity of the democratic system depends on the integrity and on the perceived integrity of the election system. And as a result, I think that we have to consider the second prong, that is making sure that people who are not entitled to vote do not vote, of equal weight with assuring that people who do vote, who are entitled to vote, should vote. So I would like to see, and I suppose this is not especially a friendly amendment, but perhaps an amendment to the amendment, that acknowledges the legitimate interest in anti-fraud measures. The second point, though, and perhaps a bigger one, is that I don't think this proposal goes far enough. I think the current system is an odd patchwork of state regulation, especially in the context of federal elections, due to the framers' erroneous, understandable but erroneous in my view, decision to commit responsibility for federal elections in the first instance to the states. And the result is the patchwork that we see, with states going in all sorts of incomprehensible directions, and very far from what you would expect to see of a national standard. The proposal retains all of this, but with an overlay of a sort of enhanced but indeterminate amount of judicial review. I say indeterminate, although the proposal does tie itself to strict scrutiny, but I don't harbor any illusions that we can actually pin the Supreme Court down through a constitutional amendment in the way that they will actually administer this, and we have certainly seen in other areas that the Supreme Court finds that things that they like pass strict scrutiny and things that they do not, and I have no doubt that that would be true here as well. So all you would be doing is inviting deeper, but not necessarily more accurate or more comforting judicial intervention, and indeed judicial intervention in elections does not have a happy history, dating at least as far back as Bush versus Gore. So what I would like to see, actually, if it were my amendment, and this is sort of beyond an unfriendly amendment, really just an alternative, but I might suggest it, is that what I would like to see is an amendment that commits all of this to Congress. And tells the national government that it is a national responsibility to have a functional, coherent national election system. And that sets forth many of the requirements that are set forth in this amendment, but it imposes them as an affirmative duty on Congress to create this system. And I think that if Congress were motivated to do this, we cannot take the courts out of it altogether, but we'd take a lot of the judicial second-guessing out if we had a national standard that we got agreement at the national level. I agree that, I recognize, of course, that doesn't solve the problem of state elections, but I think if you had a national example, many of the states would follow, and it would also give courts something to measure state laws against. So I think that would solve, it would go a ways towards solving both the difficulties we see at the national level and also set a standard for the states. Thanks.
George?
Well, as one of the few non-lawyers and political scientists here, my amendment is going to be a little different, I think, than most on this panel. I suppose I would remind particularly the law students here that America's greatest constitutional mind, James Madison, was one of the few founders who was not a lawyer. And I'm glad that Michael, in introducing Tocqueville's famous comment that almost every political question in the United States ultimately becomes a legal question, sort of varied it a little bit and said a constitutional question. I suppose I would add a little amendment to that, and it goes with the gist of my amendment, and that's that not every constitutional question in the United States is a legal question. And my proposed amendment seeks to make visible the underlying prerequisites of civil society that the Constitution depends on two fronts. But also then seeks to make those textually explicit. I didn't notice that before, that's convenient. To make those textually explicit, to command Congress to pursue policy that's necessary to secure the conditions for constitutional success. And on two fronts is where my amendment confronts us. That's first on equal economic opportunity and on equal educational opportunity. And I would say I'm not going to labor the problem of growing inequality, other than to say it's a problem mostly because I think it's increasingly a class problem. And there's a crisis, as has recently been put, of the middle-class constitution, which I think was the founders' constitution. And that problem is compounded by the fact that these are also have come to be represent, the economic division also seems to represent a cultural and civic division, so that we are increasingly living in sort of two different worlds. Now, placing these issues in constitutional texts, I want to help recover a mindset that treats economic issues and educational opportunity as constitutional issues and not simply matters of public policy. While the American Constitution is mostly silent on speaking to the presuppositions of its success and the preconditions necessary for it to be a successful constitution, those who defended it were pretty clear about many of these. And so I want to turn just for a moment to two defenders of the Constitution, James Madison and Noah Webster, who made arguments for the Constitution and drew out very clearly the necessity of both education to the successful perpetuation of the Constitution and equal economic opportunity to a successful Constitution. Now, we're familiar with, as actually Professor McConnell already quoted, Madison's notion of a large commercial republic. Part of what was key in Madison's large commercial republic would be precisely the movement of economic opportunity and the division of economic policy insofar as it would not line up in class-based ways, right? There would be not just economic mobility, but there would be a range and division of economic interests that we could both fight over and compromise on, but they wouldn't entrench in ways that might replicate something like oligarchy, a problem that not just Madison was concerned with, but Noah Webster, John Adams, and many other founders were concerned with as well. And so in terms of thinking about Madison's large commercial republic, what was necessary to the success of that would be you'd have shifting economic interests over time. And so you would not just have economic mobility upward, right, based on different economic interests and a kind of clash of interests, but there would also be economic mobility the other way, right? I mean, so that you wouldn't end up with entrenched classes of economic interests, which might then be translated into political power, which is perhaps the problem we're confronting today. In addition to that, in Madison's terms, you also needed educational opportunity. That wasn't just necessary to economic mobility, but it was also necessary to perpetuate a shared civic mindset that was essential, right, to a people that shared at least some constitutional and civic understanding, something that I think we're also seeing erode over the last couple of decades. And so it's the link really between economics on the one hand and mobility and education that that cultivates certain civic understandings that we share in common, which are often also cultural understandings. Noah Webster speaks specifically to this, and I want to quote him in defending the Constitution of the United States. And Webster says, "A general and tolerably equal distribution of landed property is the whole basis of national freedom." Webster then goes on to say that this economic mobility, avoiding powerful concentrations of wealth, are the very soul of the republic. And so by charging Congress with these issues, I seek to re-empower a public discussion about these issues, but also take them away from where too much constitutional argument currently lies, and that's with courts. And I think that there are good antecedents in the American constitutional tradition. First, there are the state constitutions, which we don't pay enough attention to. State constitutions refer not just to educational opportunity. There are even state constitutions. The Massachusetts Constitution of 1780 actually has interesting things about the problems of entrenched classes in it, as well as essentially putting Harvard, the University of Cambridge, the university in Cambridge at the time, in constitutional text and saying it's the duty of the citizenry and of the representatives to perpetuate educational and civic understandings, to be committed to the arts and the literature as part of a healthy republic. And so turning to these state constitutions, as guides for national constitutional debate, we can see that entrusting these responsibilities or constitutional commitments to Congress, can not only empower representatives and office holder to take constitutional obligations seriously, but can also have citizens turn to constitutional text and use that constitutional text to try to force representatives to take the actions necessary to secure equality of conditions, both economic and educational. Now, in addition to the state constitutions, I think the Civil War amendments are a great example of this as well in the American constitutional tradition. If we think of the Civil War amendments, the most important clauses in the 13th, 14th, and 15th amendments were really the clauses that empowered Congress to secure the rights protected in the 13th, 14th, and 15th amendments. And if we turn to the debates around the 14th Amendment in particular, those debates were largely how would Congress go about enforcing the terms of the 14th Amendment, and only sort of as a necessary afterthought or as an idea that, wait, these should also be enforceable by courts, did courts come in to the picture. And if we look at Congress in those terms, in Civil War amendments, the most important actions for securing equal rights in that regard under the 14th Amendment took place by way of the Congress in the Civil War amendments, in the Civil Rights Act. You get first, prior to the 14th Amendment, the Civil Rights Act of 1866, which really is the precursor to the 14th Amendment in an effort to protect the 13th Amendment, the conditions necessary to truly make the 13th Amendment meaningful, and then you get Congress's Civil Rights Act of 1875, which, again, the most important act in actually trying to make equality real in constitutional terms. And then you can kind of run up all the way to the Civil Rights Act of 1964, whereas the judicial interpretation of equal protection, at least as regarding African Americans, was essentially dormant as a legal protection for nearly 100 years. So I want to just kind of preempt a criticism that making this enforceable is a command to Congress, but a non-judicially enforceable command is a sort of empty constitutional gesture. I want to take that off the table or provoke an argument about that, because I want to push the argument that part of our constitutional problem is precisely that too many constitutional questions are seen largely in legal terms, and the Constitution is seen to be something enforced largely by courts. And in that sense, it's citizens and representatives, especially members of Congress, who have abdicated their constitutional responsibilities. And so my amendment has the sort of bonus of pushing representatives, members of the political branches and the citizenry, to act on their constitutional duties, to act to maintain the Constitution over time, and to do so in ways that do not take judicial form. Thank you.
Thank you. Now we'll hear from Michael Grieve, the Scalia Law School, George Mason University.
very much. Look, I'm much more sympathetic to the sort of class analysis here for reasons that you'll see in a second than many of my libertarian and conservative friends. But I'm still against this. And the reason is that it reads like something that's been lifted from the Lisbon Treaty or from the sort of more vacuous parts of Eastern European constitutions. Right, and I think, I mean, the point I want to focus on is, I think George will concede that this is a bit at odds with our formalist constitutional tradition. I think it's very much at odds with it. Maybe it's time to sort of forget about the formalism and say we're all Europeans now. But I think it's important to realize, you know, that this would be a break, what exactly it is we're breaking with and what that would entail. As you've already discovered, probably, I received my undergrad education in Germany. And what they feed you there is Hegel, morning, day, and night, the philosophy of right. And among the sort of sensible insights in the philosophy of right is actually this. And Hegel says, look, you cannot run a liberal constitutional regime in a class society. But a class society is precisely what you're going to get once you unleash sort of the spirit of liberty. And to fix that, Hegel had an amazingly progressive program, a welfare state, believe it or not, broad-based public education, corporations, which is what we call mediating institutions, and a big government bureaucracy, not because he was infatuated with the state, although that was also true, but because federal bureaucrats would be paid living wages, and you need that to support a middle class. That's Hegel, that's Europe, that's 2 centuries ago, but that's this program, it seems to me. And it's driven by precisely the same insight, and that I think is so not us. What I think is right about George's proposal is this. Look, I've read enough Tocqueville to know that the Constitution owes a great deal to the absence of class distinctions at the time. I agree that the founders understood that the Constitution presupposed some degree of equality along with education and a certain degree of civic virtue. But it's all the more amazing that the Constitution, as it's written, then does not have a single word to say about that. It leaves all of that open to ordinary politics and lets the results be what they may. It's equally amazing that a century later, when the question of the fate of a liberal constitution in a class society arose again, and in full force, we did not go Hegel's way of sort of committing ourselves to this or that social arrangement. We tinkered with the mechanics of government, just as Madison did, and we let the outcomes again be what they may. I mean, who knows how women might vote, right? The one exception to that is the 18th Amendment. That was sort of a constitutional effort to force and produce civic virtue and social policy by edict, and that was repealed because it simply doesn't fit. So that's the tradition, I think, with which this amendment would break. It's very vehemently, I think, anti-formalist, and you'd have to think through how to create, sounding like Bruce Ackerman, but it's some synthesis between, you know, what this does and our formalist constitution. Could Congress delegate these duties and create a sort of commission for public equality and fork over sort of $800 billion and be done with it? Would that do it? Could it give the states a boatload of money pursuant to this on the grounds that education or whatever it is, equality is a national obligation but a local task, to paraphrase President Bush? Suppose that Congress enacts some law and some agency then arguably falls down on it. Could you sue on those grounds for the enforcement of the law? I think in a system of sort of federal separated powers, you're going to get, with judicial review, you're going to get all those questions. And I'd like to know what the answers might look like. I think the deeper question that I have here is about the nature of constitutionalism and politics. So what I think our constitutional formalism reflects is sort of two corresponding convictions. One is you trust ordinary politics, provided you get the institutions right, signed James Madison. And two, you really hate utopian politics, signed Alexander Hamilton. Right, and Europeans can't have that formalism. I mean, they haven't gotten the institutions right in 300 years. Right, and on point two, they really like to believe that all would be well if we could just set aside our childish interest group conflicts and opinions and promote the welfare of the whole people. That's what gets Mr. Macron elected. That's why they have all this utopian claptrap in the constitutions. I understand the despair over ordinary politics, and I get George's impulse completely to sort of re-infuse our politics with some sense of purpose, but at least for now, I'm more distrustful of utopian politics, right? So the inequality problem now is front and center, and I think Congress doesn't need a constitutional amendment to focus on it. It's just that the reality might be there's not a whole lot that you can do about it at the end of the day. That's a harsh conclusion, but I don't think that sort of the appeal to higher purposes will fix it.
Thanks, Michael. Our last presenter is Amy Wax.
Well, my presentation does continue the theme of mistrust of ordinary politics, and especially of utopian politics, I guess. So this amendment was motivated by a phenomenon that I have noticed, which I will call sort of the proliferation of disparate impact thinking, or the disparate impact mindset. And that thinking can be defined as a focus on the impacts or effects of various laws, policies, arrangements, steps, measures that are taken both by private and public actors in society. And this concomitant suspiciousness towards any effects or impacts that are unequal as opposed to equal between various groups defined by the usual identity categories. And of course, one of the problems here is that those groups, identity groups, have proliferated wildly in our society, which means that the number of disparate impacts from otherwise neutral policies or arrangements have proliferated as well. The idea being that any inequality as between groups is per se undesirable or suspect or intolerable, something to be corrected, and especially something to be corrected by a government service or program or intervention, which will necessarily have the effect of greatly increasing the amount of power that the government is exercising, the number of projects of social engineering that it will undertake. And I will just lay my cards on the table and say that I think that all of that is in derogation of liberty. I often say to people, after I've ridden on Amtrak or New Jersey Transit, what we need is more engineering and less social engineering. So disparate impact liability has been widely imposed under federal anti-discrimination laws, and I'm just going to give a few examples of where I think disparate impact thinking has had a great deal of influence recently, and really the number of contexts is growing. It's disparate impact liability has been imposed in employment, in housing, in financial services, for mortgages and banking, recently for bail, for school discipline. The list is really endless, and I'm just going to focus very briefly on three of them and then explain why I think in each case the developments have been undesirable. It all started with this decision many are familiar with, Griggs v. Duke Power Company, where the Supreme Court held that liability could be imposed under the federal anti-discrimination laws, employment anti-discrimination laws, when an employer adopts a policy or practice with a differential impact on a protected group, even if that policy or practice is neutral, that is, not strictly because of race or motivated by race, but just having a differential impact by race, unless that measure can be defended by showing a business necessity. So that's sort of the defense there, right? Just 2 years ago, a similar paradigm was adopted under the Federal Fair Housing Act in Texas Department of Housing versus Inclusive Communities. The Supreme Court held that a policy or practice with an adverse impact on a group protected from housing discrimination violates the statute unless that practice serves a valid or legitimate interest analogous to the business necessity, didn't define what that interest would be. And then finally, practices with a disparate impact can also violate Title IV or VI of the Civil Rights Act, which protects students from discrimination in federally funded programs. And under the Obama administration's 212 Dear Colleague letter from the Department of Education, disciplinary practices for misbehavior of school children that are, quote, administered in an even-handed manner but have a disparate impact on protected minorities are hereby unlawful unless necessary to meet an important educational goal for which there's no comparably effective alternative. So those are sort of three examples there of how disparate impact liability or regulation plays out. Now, why do I propose this amendment and what is it designed to achieve? There's sort of one big idea here, and then there are a couple of littler ideas. The big idea is that equating disparate impact with discrimination indulges a strong presumption that equality of outcomes for different groups is to be expected and is desirable in itself. But I submit that even though we have reason to be concerned about inequality in our society, and we should perhaps address it in various ways, addressing it through indulging this assumption is unwarranted and very costly given social and economic realities on the ground and some of the positive effects that these suspect measures are trying to bring about. Frankly, disparate impact initiatives focus on the symptoms rather than the disease. So in deploying legal force majeure to achieve equality of result, they deflect attention and resources from efforts to address so-called root causes of disparities, which in many cases would produce more and more enduring social equality. And then as a sort of side effect, imposing disparate impact liability, especially under federal civil rights laws, transfers a lot of discretionary authority to courts and federal officials, which ultimately ought to reside in localities. It operates in derogation of local prerogatives and flexibility, both public and private. So those are sort of the big vices, I think, of disparate impact, the proliferation of disparate impact thinking here. But there are a few sort of, shall we say, shortcomings that vary by context. So take disparate impact in employment. It flies in the face of some inconvenient factual realities. Groups are not, on average, equally qualified for all jobs, so similar employment patterns should not be expected, right? I mean, that's just a completely unrealistic, shall I say, utopian expectation. And the requirement of defending sensible job selection methods imposes a very expensive and in many cases impossible to meet burden on employers, and the result here is both unfair and inefficient. In the housing context, the nature and complexity of markets and the wide range of priorities for housing means that disparate impact mandates will end up imposing multiple and conflicting effects on protected groups. So taking an example of a case the Supreme Court actually accepted but then dismissed because it was settled, right? A St. Paul, Minnesota housing code was challenged on the basis of adverse impacts on cities' low-income Black populations because it made housing more expensive, but the whole purpose of the code was to protect low-income populations from substandard housing. So we see these sort of conflicting priorities. And then, once again, the arbitrariness is compounded by the uncertainty of what a valid justification for a particular housing policy would be. And it's a complete crapshoot what the court decides would be a valid justification. Finally, in school discipline, disparate impact policies allow centralized authorities to substitute their judgment for local school officials, jeopardizing their ability to deal with realities on the ground, right? There are valid reasons why school disciplinary policies have differential effects on different groups, once again, because of the reality that misbehavior is not evenly distributed throughout the population. For example, in St. Paul, Minnesota, both white and Black students are sanctioned at many times the rate of Asian students. And I don't think we can say that white students somehow are being deliberately discriminated against. So the point is that rules that assume behavioral uniformity, despite facts to the contrary, are perverse and can produce perverse results. And in fact, and I don't have time to get into it, there are now a number of studies out of a number of cities that have adopted this sort of quota system of school discipline that show that disorder in the classroom has markedly increased, hurting students from all groups. So there are a number of questions and problems that can be considered in light of this amendment, and it's one of those amendments you come up with at 3 in the morning that probably have all sorts of hidden pitfalls. Just very briefly, a couple of them, and I'll leave the rest to my commentator. Disparate impacts can be used as evidence for intentional discrimination, obviously, and they always have been used in that way in courts of law. And I don't mean my amendment to bar that. Surely, sometimes disparate impacts are sort of the first step in proving actual discrimination by race or by sex or by other categories, and that would not be ruled out. What I'm trying to rule out is the kind of per se liability as such, or creating and crafting policies or mandates based on the mere fact of differences or differential impacts of particular policies or actions. That's really all that I'm trying to do here. Whether I'll actually succeed in that, of course, is another question. And then the second question is whether this somehow bars trying to prove unconscious intentional discrimination. And I personally believe, and I've written about this, that intentional discrimination, disparate treatment, can be conscious or unconscious, and that ought to be actionable. So I don't really intend to disturb that. Beyond that, how this will actually play out in arenas other than kind of core anti-discrimination law remains to be explored, remains to be seen, because obviously there are all sorts of neutral measures, steps, policies that can have, that can either address differential outcomes or that can have differential outcomes.
Thanks, Amy. We'll hear commentary from Sandy Levinson from the University of Texas Law School. Pardon me? 5 minutes, please.
Thank you. I'll skip over any extended expressions of thanks for the invitation to spend the 5 minutes on the amendment. Not surprisingly, I although I hope I'm friendly in my demeanor, I'm not particularly friendly to this amendment, for three quite different reasons which actually come together. One of them is a meta reason that, as will come out tomorrow, I do believe the Constitution needs fixing, but I'm obsessed with structural features of the Constitution, not rights provisions. I tend to agree with Madison that most rights provisions are parchment barriers that can pretty much mean whatever judges or interpreters want them to mean. Indeed, in the book I've written, I've distinguished between what I call the Constitution of Conversation, which law professors obsess on, and the Constitution of Settlement, which we never teach because there's no litigation. And rights provisions are notoriously within the Constitution of Conversation, and this would just add to that. So then this comes to a second point, which is that insofar as the desire for the amendment rests on a desire to lessen the judicial role, I just don't think he'll do it. That Professor Wax is much too good and careful a scholar really to pretend that it will, because she, in her very thoughtful comments, she mentions that there will be a, quote, raft of hard cases, unquote, and that there will be a lot of, quote, tricky, unquote, issues that will come up. This is absolutely correct. And who's going to decide these hard cases and tricky issues? It's going to be judges, whether one likes that or not. And you'll simply have more and more litigation based on the higher metaphysics of what one does with disparate impact and whether this is adequate proof of animus and the like. So insofar as this is inclined to reduce the role of judges, I think quite frankly, it is destined to be a failure. Also, I confess, and this is simply, I suppose, a political disagreement, but George Thomas evoked Madison, whether or not one shares the complete level of esteem that George or Jack Rakove might have for James Madison. He was clearly a very, very interesting and smart person, and I do believe that Federalist 10 deserves its place in the pantheon. But the way I read Federalist 10 is as a rigorous, thoroughgoing critique of local government, that local governments are cesspools of faction, and nobody would ever look to local government as a way of trying to prevent tyranny of the majority, if that is a concern of yours. So I just don't share the belief that if we return all of these decisions to more local decision makers, the world would be a happier place. But that is clearly a political disagreement that not only Professor Wax and I have, but it goes back quite literally to the very founding moments. But then I suppose the last reason for my hesitation to abolish, or to attempt to abolish, however futile I think it would be, the emphasis on disparate impact, is that I think that disparate impact in its own way serves as a valuable prophylactic against calling our fellow citizens and our decision makers racists or sociopaths or anti-religious bigots or fill in the blank with whatever insult you'd like to throw around. Because the more you require intentionality tests, then you really have to show that the school board was not merely thoughtless, whether it is in drawing lines that run adverse to African Americans or denying a religious organization the right to use a public school. Mike McConnell and my former colleague Doug Laycock have very much shaped my thought with regard to equality in the religious. And quite frankly, many of those claims are disparate impact claims. And where it may be that often secular people are just a little bit thoughtless. And it seems to me that one value of disparate impact analysis, conceding that it has problems, but what doctrine doesn't have problems? In all cases, we have to talk ultimately about frequency distributions. The false positives, false negatives, type 1 errors, type 2 errors, and the like. No doubt Professor Wax can bring to our attention and valuably brings to attention cases that we might agree are extreme and probably should have been decided otherwise. But I think one can also bring cases in which you would agree that disparate impact analysis is correct. And I think that Griggs versus Duke Power is a perfect example, and it might be because I'm a Tar Heel born and bred. And quite frankly, I just don't trust the Duke Power Company, at least as of 1972. And rather than say that they were run by a bunch of racists whom we have to stomp on, I think it's enough to say, you know, we would like you to follow a kind of due process of law that will simply explain why you are using these tests to hire your workers when there is really a lot of evidence that it cuts against a universe of people that, you know, you might not entirely be taking into account as much as you should. And I think overall, we're better off trying to minimize the frequency with which we have to insult one another in saying that they're legally liable for something, and indeed can kind of soften the blow and say, well, maybe you just haven't thought about this enough. And so why don't you explain why you've adopted this policy that has these consequences, which are really quite unfortunate.
Thank you. Thanks to all our presenters and also commentators. Because everyone was so conscientious, maybe unexpectedly conscientious, we have plenty of time for audience questions. So if you have a question, please go to one of the microphones you'll see at the far aisles so that everyone can hear you. And yeah, take it away. Please.
So a question for Professor Schacter, Professor Wax, and maybe even for Professor Levinson, who taught me at Princeton a long time ago. And I now remember where I met you. Disparate impact. Is it discriminatory disparate impact for a public institution to charge $3 for a loaf of bread because it has an adverse impact on the poor, for whom $3 is more than a rich person, and black and brown people disproportionately poor? It seems the argument falls apart when you start putting poverty in the middle of it, number one. Number two, with respect to education, what ends up happening when you apply disparate impact is you get schools throwing out things like GPAs, test scores, because of disparate impact theory, and it seems like we're dumbing down the entire culture due to use of disparate impact.
Well, I'm not going to seriously disagree with you. I think, you know, there's those two examples you give have at least in the law received rather different treatment. So poverty, you know, no Supreme Court case has recognized a sort of legally viable cause of action for disparate impact by income, but in the popular thinking, certainly, and it started to creep into the lower courts, disparate impacts based on ability to pay. Certainly, it's come into public policy. There have been two articles in the New York Times recently on this, one about trying to retire the policy of denying school lunches to children whose parents haven't paid for their school lunches. That's a little bit motivated by, you know, well, it's wrong, it's unfair, it's adverse to allow our policies to have a differential impact based on parents' ability to pay, right? Library fines, we can't impose library fines anymore. Because that's stigmatizing to poor people. So, I mean, that kind of thinking is out there. I don't think it has a home in the law quite yet, but it might someday soon.
Isn't that what the voter ID cases are all about, though? Is the idea that the burden imposed by voter ID hits people disproportionately based upon the time and effort and money to get the ID?
But I don't think it's based directly on their income as such, or economic position as such. But the second point you're making, I think, is very much goes to the heart of what I'm trying to say here, which is that we're sacrificing important prerogatives, important goals and values on, the altar of differential outcomes. In the law, there is this supposed defense that one can justify disparate impacts by showing a legitimate purpose. Very often, though, that kind of gets thrown out because it's so hard to do. Policymakers and actors in the economy, they're not psychometricians, they're not, data collectors, they're not people who ordinarily run regression analyses. They're not really in the position to justify the validity of a lot of what they do, like using tests or using screens or other criteria. So those criteria get thrown out, and I think, or dumbed down or softened. And I think we all suffer, including poor people, including people who aren't terribly privileged. I mean, the hoary wisdom is that some very ordinary, humble people have gotten ahead precisely by scoring well on these sorts of tests and studying hard and the like, and that avenue is now going to be closed off. So the cost is great. It sounds good and it feels good, but at the end of the day, a lot of people are hurt by it. The sort of, that never really gets brought out.
I just want to jump in on your question as it relates to voting, because to the extent our equal protection doctrine reflects protection for people who can't pay fees, you talked about, you don't have $3 for a loaf of bread, it's gotten attached not to any broad skepticism about wealth or poverty as a basis of classifying. And in fact, in Washington versus Davis, which is the leading case saying you need intent, not just disparate impact to make out a racial discrimination claim and trigger strict scrutiny, the court points to where would the stopping point be. We have all kinds of fees that governments impose. But the way the doctrine has shaped it is to hitch the obligation to pay a fee to something that is treated as particularly important. So, for example, Harper, the case I referred to, recognizing a fundamental right to vote, is a poll tax vote. Some people can pay the poll tax with no problem and other people can't, and it gets struck down. There are other fees to pursue certain kinds of appeals, fees to get a divorce. There's a little line of cases, and they don't have a clear unifying principle other than the court thinks this is something particularly important where, and so there, has arisen a question about that body of law. Is it inconsistent with the Washington versus Davis requirement of intent? But it's quite a modest list, so it's not any kind of constitutionalization of disparate impact. But I do think that voting and voter ID, the argument is made in these voter ID cases that it's like a poll tax. If somebody has to pay a fee that is particularly onerous for them to get a very specific kind of ID that's required, or has to go through a lot of motions to get a birth certificate that's, expensive, that because it affects their ability to vote, that's significant. Now, that is really different than saying we shouldn't require any kind of ID or we shouldn't pay attention, as Michael suggested earlier, to the problem of fraud. The question is, how is the particular rule drawn and tailored? Because there are ways to do it that don't impair the right to vote meaningfully, and there are ways to do it that do, and I think states are sometimes making choices of the more burdensome variety because of the political consequences.
Thank you.
Thank you. Just two quick comments, very quick comments, and a question. The first comment is that I think consistent with Sandy Levinson's comments, I think a lot of the concerns expressed by Professor Wax speak to the level of scrutiny that one applies to disparate impact, which one can obviously tinker with in various ways. I worry that making disparate impact liability not cognizable at all, I worry about the injury that it performs, just as Sandy mentioned, the injury it performs to social cohesion when we associate anti-discrimination law with a moral injury exclusively. So I worry about exactly the worry that Sandy has. For George Thomas, I like directive principles in general as a matter of constitutional design. I don't know about it if I like it for the United States necessarily, but as a matter of constitutional design, I'm quite sympathetic. I do worry about putting in the Constitution that the provisions are not judicially enforceable, not because I think provisions always have to be judicially enforceable in the usual way, but that it's sometimes the case that there are ways of judicial intervention that don't look exactly like enforcing the provision itself. So for example, if Congress is motivated by a particular directive principle or economic equality or whatever, we might want judges in rights cases to take account of that in the course of doing so. And I think that's actually the greatest benefit of something like an affirmative duty. So maybe it's a drafting issue, but I'm not sure. The question is for Marian Case and goes back to this disparate impact issue. And Michael Stokes-Paulson mentioned that when you put in a provision that looks like it mimics the existing doctrine, judges are going to search for what's different. And I wonder if one should anticipate that an equal rights amendment would include disparate impact liability, and what we should think about that.
So, again, I'm not happy about having to propose the Equal Rights Amendment. It's bad enough that there had to be even the constitutional revolution because people like me, just to get to the starting line, have to expend a lot of political effort or legal effort that other people can spend on other issues. But I think it may be necessary because I do the long history of feminism, and there's a lot of retrograde. I also do comparative law, right? And I see both over long history, 500-600 years, and over the face of the earth. Afghanistan, we were talking at lunch about Turkey, women's rights suffering retrogression, the equality of the sexes, the liberty of the sexes in their relations to one another, suffering retrogression. So that's why I feel like the ERA is necessary. I very deliberately, I would reject almost any change in the language because I think what we have with the language is a fixing of the existing doctrine because of the history of the ERA, right? Because everyone on both sides of the ERA, the opponents and the proponents, agree that our current doctrine is what the ERA would have provided. Now, as to disparate impact, I think Feeney is wrongly decided. I have no problem with the Washington v. Davis disparate impact standard that there has to be some intent connected to it, that a particular facially neutral decision was taken because of and not despite its disparate impact. I think, however, as several scholars, including myself, have written, the facts of Feeney, which reserve for veterans basically all of the higher level positions in the Massachusetts civil service by giving them an automatic boost to their scores, but exempt pink collar jobs. The facts of Feeney do show that it was because it was not in spite of, but to some extent because of veterans who were overwhelmingly male that the action was taken. And if I can use the occasion to say, I'm a big fan of disparate impact and its effects in employment discrimination law for reasons somewhat different from those already mentioned, which are that it's not just that we're a little thoughtless in ways that harm individuals because of their protected characteristics or forbidden grounds or group status, but that the society is harmed by a thoughtless perpetuation of standards that do not work I'll take the Supreme Court case of Ricci as my example here, although it's not a sex discrimination case. I could cite sex discrimination cases about things like tests for firefighters and tests for police officers that work in pretty much the same way. I'm very upset by the result in Ricci, not because of its effects on the applicants from racial minorities for firefighting positions, but because I don't want to die in a fire in New Haven. I go to New Haven fairly frequently. And what Disparate Impact does is say, is the test that we have established, which you can work hard and study hard for and do very well on, does it bear the relation we want it to the task we are asking the people we are hiring to perform? And what disparate impact law does is cause us to interrogate those tests. And the finding in Ricci is similar to the finding I'm familiar with respect to police officers and firefighters with respect to sex, that the answer is no. That doing well on this paper and pencil test has less correlation to fighting fires effectively than the substitute test that a disparate impact study proposed.
Can I speak a little bit to the question of constitutional design? I mean, it's interesting you say that you don't know if you like them for the American Constitution, even though they could be good elsewhere. I mean, I would first say the U.S. Constitution has a little bit of that in it. There's the Republican Guarantee Clause, which we say, oh, mostly it's a dead letter, but it was really used pretty powerfully in the run-up to the Civil War and in framing the 13th, 14th amendments, and there is the preamble, which we sometimes tend to forget about. That might not empower, but it is certainly suggestive. And what I wonder then is, to go back to Michael Grieve's point about our formalistic Constitution, I wonder if that's part of big constitutional failure. I mean, if the Constitution in some way teaches citizens and representatives, that, those who aren't judges or justices, that they're not responsible for carrying the Constitution forward, right? Both in terms of its commitments and in actually just having a real understanding of what it means to engage in constitutional self-government. And then I'm going to point again, despite Grieve's attempt to say this comes out of Lisbon, to say that I doubt very much that John Adams, in writing the Constitution of 1780, was reading Hegel in that case, right? I mean, these come right out of the Virginia Declaration of Rights of 1776 and the Massachusetts Constitution of 1780. And it's interesting, especially for somebody who likes federalism so much, that somehow the state constitutional tradition, which actually have so many of these active principles, right? I mean, which would make sort of Lisbon people blush in terms of their charge to citizens in thinking about the Constitution. So I wonder why that tradition is altogether neglected. And it would be an interesting comparison in terms of maintaining the Constitution. Do the states more actively engage the citizenry to that regard, and non-judicial public officers, and have the state constitutions in that regard been perhaps more successful than the federal Constitution?
Go ahead.
Sure. Thank you. I had one question for Professor Schacter and one for Professor Thomas, so I think I'll put them both out there. I appreciate the idea of drawing a bright legal line between incarceration and not for voting, but it strikes me that there's varying degrees of incarceration and work releases and halfway houses, and I wonder if the line is not that bright, and if not, who gets to draw the line? Will it still be up to states? And then Professor Thomas, I was wondering if you might expand a little bit more on the role of the judiciary in policing or not policing what Congress does with these affirmative duties. So for example, if Congress has an affirmative duty to expand educational opportunities and chooses to do so through some kind of voucher program to sectarian schools, can the court still step in and say something about that?
Can't say I've thought about all of those variations, but I guess if the intent of the drafter mattered, it would have been to say once you're out, say in a halfway house, you're in the community, you're working, that's the important line. As far as work release, I guess that's kind of a borderline case. Like, what approach would the it would ultimately fall to a court. Somebody would say, hey, I should be able to vote, I'm out, but I'm in a work release program, so am I going back to the jail at night? I mean, the bias of the proposal is more voting, but it recognizes that there's a distinct set of administrative issues and a kind of an underlying justification that doesn't necessarily operate when someone's still incarcerated. So I think that's one of those things that would have to be kind of worked out on a case-by-case basis. But if we thought about purpose, it would be toward more voting.
First I said I would want the courts mostly out of this, mostly because I think if I find myself on the equality panel kind of by happenstance, I'd put on the panel of Congress as kind of a constitutional failure. I mean, that's one of those areas where the Constitution really just has not worked as Madison and others thought it would. It doesn't sweep everything into its vortex. It has unbelievable power that it usually chooses not to exercise. And so I don't want to give anything to the courts because I want the burden to be fully on Congress. Now, maybe that doesn't work, but in your question, I take it, that would be indirect. I mean, so no Congress, so if the question is, could Congress do things with regard to education that it might be prohibited from doing by, say, the First Amendment, it would be different, I think, to say, no, Congress can't, I actually think Congress could give vouchers to religious schools, but let's say one thought is a jurisprudential matter that they couldn't on First Amendment grounds, that would be different, right? I mean, you'd be saying Congress can't take this action because the Constitution has already elsewhere prohibited that sort of action. So yes, courts would probably very much have an indirect role in some of these things in terms of policing congressional power.
Thank you, Amy and Mary, but I'm going to go back to George and Jane. So Jane, I think the most shocking thing in your proposal is that it applies to those who are incarcerated, and there's all kinds of different possible justifications, but it wasn't clear from anything you said why, given that's fairly common practice in many countries in 2 states, to allow incarcerated people to vote, what your political theory was, because we're not talking about what's politically viable.
Yeah, right.
And then my question for George was, as you know, Noah Webster also was a great enemy of luxury. And I feel like there's this moment right now, and Ganesh Siddharaman's book sort of calls on that, where there's a revival of an equality tradition, but a real anxiety about reviving the hatred of luxury part of the revival of the equality tradition. And the particular as-applied question then would be in the context of public education, where you don't call for adequate public education, but equal public education, which, forget law for a second, but in a utopian practice would mean banning certain kinds of private schools and the sort of higher end, and actually using our public rhetoric and our role as George Thomas constitutionalists to be anti-luxury people. This isn't an attack, it's a genuine question about your sort of philosophy and approach towards inequality when it doesn't mean poverty, but means inequality without poverty.
So in answer to the question about line drawing, I think that political viability is off the table, but as I thought about this proposal, it probably snuck back in the back door, not in the sense that it would be, I wasn't thinking about what could get passed, but I was anticipating resistance to the basic idea and thinking that ultimately constitutional norms that have more buy-in and are more acceptable are less likely to produce pushback and resistance. And that this was, as I said, kind of an intuitive line that kind of makes some functional sense. And so I have to cop to a little bit of pragmatism. Same thing was, my initial thought was to mandate, not voting, but mandate every eligible citizen to go to the polls. And you don't have to vote once you get there. You can just, this is, I think, Australia. You can say, I don't want to vote, check off a box, and leave. And, you know, it's the same kind of idea. Like, I think that would be more efficient. It would, you know, could be done at the federal level. It could be applied to states. It could be take care of everything. number one, I think we don't have the capacity probably to deal with that. And number two, it's sort of like the same pragmatic impulse that the culture is just going to rebel and revolt, whereas some of these other things might be significant interventions that wouldn't inspire the same resistance. So.
Yeah, that's a excellent and tough question that we would have to debate out in the legislature. I mean, I guess where I would have a reservation is it's equal educational opportunity. And so it seems that it would be hard to say you would prohibit something like private schools, which is what I take it you were suggesting could be a possibility. But it may well then, given the look at private schools, and if you look at elite institutions, I mean, what's really troubling in economic terms, and should trouble, I think, the right as much as the left in that regard, is the degree to which the percentage of students there, climbs higher and higher, where you're talking about, the top 5% of income or so makes up sometimes 70 and upward % of the student population. That would, rather than, shutting those institutions down, I suppose that, could be one way to try to do that. It would really be that you'd have to bring the other institutions up in that regard. But I mean, to have that very debate in Congress is a matter of public policy, but not just as public policy, but as a constitutional commitment, right? I mean, that's what I'd really want to stir. And again, I don't want, where'd Grieva go? He's picking on him, but he's not even he's somewhere over there. But, I mean, when did educational opportunity, when did equal opportunity become utopian altogether? I mean, I get if the outcome were egalitarian, total, so then you would be taking private schools and off the table. I would be deeply troubled by that, and I think that kind of egalitarianism would be seriously problematic, but we're talking about opportunity is all, and so I think that it would put the burden on Congress to go to public schools and make sure that there was what we could call at least a rough equality of opportunity.
Great, thanks. My question's for Marianne. I disagree with Professor Paulson in that the Equal Protection Clause is ambiguous in some way, but I appreciate your concern about originalism's assault, essentially on how sex is understood under the Constitution. With that said, it feels very last century, and I'm just wondering why you chose language with discrimination based on essentially anisogamy and not looking at things of gender. So you based it on sex and not necessarily gender. Why you didn't take account, why it's discrimination based on anisogamy or the concept of sex, like your actual sex organs, and not based on concepts of gender, which is a much more 21st century understanding when you think of transgender, bigender, all the bathroom battles that we're going through currently. Why would you choose sex and not sex and gender? And why not take account of some of these deeper concerns about equality the way they're understood in the 21st century and not just the 20th century?
So I have to reiterate, there's a technical term for this in Congress that where you can't change the words because to change the words would be to undo things. It's what the Affordable Care Act was stuck doing. I feel like I'm stuck with the text of the Equal Rights Amendment precisely to avoid Professor Green's problem, which the problem that if we change the words, there's a risk that we will debate about whether the meaning has changed. So I'm going to stick to the words. I think the words have a more radical implication for equality along all lines of sex and gender than certainly Professor Paulson's suggestion of men and women, and your somewhat confusing, not that you're confused, but confusing suggestion of sex and gender. This also gets to what my commitments are with respect to equality and liberty. I think you should have rights irrespective of what categories you fit into rather than because of what categories you fit into. And the thing about prohibiting discrimination or guaranteeing equality on the basis of sex is that it doesn't force anyone to say what sex you are. Men, women, transgender, intersex, whatever. It just says if your sex is different, if the reason you are being treated the way you are is because the government or the law or the government actor believes your sex to be whatever he, she, or it believes it to be. And if your sex were other than that, you'd be treated differently. That's enough of a problem. That's what Title VII does, quite revolutionarily. I am with the Seventh Circuit, which has finally come around to the proposition that the Title VII prohibition on of discrimination on the basis of sex doesn't require you to specify an identity category, but simply says treating people, if your sex is a but-for cause of the way the government treats you or the inequality the government forces you to suffer, that's enough.
So I have a practical question for Jane, or it's sort of two parts, but I think they're the same question underlying it, which is it, in your opinion, based upon actual evidence about how election law works and is enforced, are there ways to improve the integrity of the rolls? And this is called voter fraud, but I gather, I don't know a lot about this, but I gather that a lot of the problem is not so much people presenting themselves at the polling place under false auspices as voter registration rolls that are out of date and a variety of things. But my question for you is, are there ways to protect against fraud and improve the integrity of the voting process that don't suppress the vote? And just as maybe this is a friendly amendment, that to include that, a commitment to that would greatly improve the political attractiveness of your proposal.
Yeah.
And then this is a related question, but in the same vein, I worry about the emphasis in the long section of your amendment on voting outside of the polling place, things like absentee ballots, because I think the secret ballot, by the way, I would also throw in a guarantee of the secret ballot, which we didn't have until, the late 19th century. I think the secrecy of the ballot is extremely important, and I worry about some of these non-voting place methods of voting and whether they undermine the secret ballot. I don't know how much of this is urban legend, or what, but one hears about things like absentee ballots being sent to the nursing home, and they just sort of march all the people in and vote them the way they want to. I don't know whether that happens or it doesn't, but it sure seems like it could. And so I'm wondering whether that emphasis in that portion of the amendment may be problematic.
Yeah.
And I would just encourage you to think about ways in which, without discouraging access, we could ward against some of the potential abuses that people worry about.
Well, one of the reasons I didn't mandate in the amendment, you must have a certain amount of early voting, or you must have, is to leave some discretion for that, recognizing that that might also be a problem, but having the standard be facilitate voting for people. I think in terms of, voter fraud, there is a lot of urban legend, but there's not zero fraud. There's not zero fraud, and there's certainly not zero record-keeping problems as far as people being on the rolls after they've moved and so forth. I think there are better versions of voter ID which make it less burdensome to get one, which expand the category of what counts as one, which may, offer subsidies for people who can't afford it. And I think the Missouri case was kind of an example of how to look at that, don't discount the problem of fraud, but look at its actual impacts and the more narrowly tailored way to do it. I think that one of the reasons I did put universal registration in is that is a way to deal with some of these record-keeping issues, because once you're in the system, it's sort of like if you move what happens to your driver's license? I mean, there's a whole set of things that state governments deal with already, and it might be able to be assimilated into that. I mean, two issues, and Rick knows a lot more about this than I do, but two issues. One is that, one of the driving force behind universal regulation is a belief in a greater role for digitizing databases and having everything online, and we're living in a moment where we're going to wonder about the security of that. So that is obviously, a big picture issue to sort of secure voter databases, and universal registration would have to cope with that. I forget what the second thing I was going to say was, but maybe it'll pop back into my head. Want to throw something in there?
Well, I'll just respond a little bit to Michael. So the problem that is so baffling with much of U.S. government, and it plays out in this context with the voting rolls and all of that, is we just don't have national databases because we don't have national ID cards. And so what you're trying to do is integrate different databases. So the voter registration rolls, how are you listed on those rolls? When you move and you change address, are you listed under the exact same name? When you die, is the middle initial used or not used? And so the problem is a massive bureaucratic problem that a lot of people have been working on. States have been trying to improve these voter rolls, but a lot of it is just the incredible decentralization of all this information in the United States and the failure to have databases that can integrate effectively, and that can be improved.
It's also a funding issue, right? I mean, that's the other thing I meant to say, that you need more resources thrown at this to do it as well as possible, and the states don't have them, right? Don't want to use them.
I did want to press you a little bit on the voting issue. So, and this goes to Sandy's comment about thinking in terms of rights versus thinking in terms of institutional structures. So I noticed that, your focus and how to improve the voting system is by creating an individual right, although it's an affirmative right, to a, kind of structural commitment with courts enforcing it. But it's still the case, even under your system, that you're going to have legislators who are constantly engaging with these sorts of issues. And of course, they inevitably bring their own incumbent protecting and partisan protecting self-interest to bear on even under your new regime.
Sure.
So why not think in terms of changing the institutional structure more dramatically and take a certain amount of this out of the hands of sitting legislatures, as in fact many modern constitutions do. Post-World War II constitutions, in a number of places create various kinds of commissions or independent entities of various sorts to regulate various aspects of the electoral process. And of course, there's no, you don't have to have an illusion about neutrality and independence to think that it's better to be at least one step removed from the most self-interested political actors having the power over this. So I would encourage thinking in more institutional rather than purely rights-oriented terms and thinking about, expansive ways of reimagining the regulatory environment for the voting system.
Yeah, that does make sense. I mean, I think there's going to be a certain amount of pushback for unaccountable actors to be able to make these decisions, but of course the fact that they're not accountable is part of what makes it attractive. So it's a tension, but I think a good point.
Okay. Seeing no further questions, please join me in thanking all of our presenters for a great panel.